Whoa, guys, what's going on?
Well, I'm suing him over there.
And I think we should go to mediation.
That's what we're talking about today.
Welcome to the Utah Real Estate Show podcast, the show where two agents and a lender teach real estate best practices by talking through mistakes we've seen and made.
But
Less expensive
I
to
still
the
want
loser.
to sue Tyler.
There we come to it. When you present the REPC, right, when you're a buyer filling out the real estate purchase contract, you have the option to select if we have a dispute, right? Everybody's going into it nice. But if we have a dispute, how are we saying we need to resolve this? Hello and welcome to another episode of the Utah Real Estate Show. I'm Tyler Kazare, Utah Real Estate Agent.
Jason Christiansen, mortgage lender.
Eric Wist, Utah Real Estate Agent.
In this episode, we are talking about disputes because Eric can't ever get it right.
Jeez.
No, I just want to sue Tyler.
Section 15 of the purchase contract. Mediation. Shall or at the option of the parties. What's the right choice?
First of all, what is mediation?
Mediation is when you get somebody to say, hey, this is what could happen, this is what they want, and help you come to a reasonable solution that both parties will agree to. There's a difference fundamentally in the purchase contract. If you litigate, the loser pays. If you mediate, the fee is split equally between the parties.
It's cheaper. It's usually a little bit nicer.
Quicker.
Yeah, it's going to be way faster.
Way faster.
And a lot less expensive. Potentially thousands and thousands of dollars less expensive, depending on the dispute.
But
less expensive
I
to
still
the
want
loser.
to sue Tyler.
And there we come to it. When you present the REPC, right, when you're a buyer filling out the real estate purchase contract, you have the option to select if we have a dispute, right? Everybody's going into it nice. But if we have a dispute, how are we saying we need to resolve this? It is the buyer who determines how this is going to be resolved.
Well, they present it. It could be countered in an addendum.
Yeah, a seller could say, no, I absolutely want the right to sue you, or whatever the case is.
One or the other.
So let's talk about both those parties, right? Or both the options. If you say may, if I say I want to mediate and Eric says he wants to litigate, he wants to sue me, who wins? I said first, right? I said that I wanted to go.
It's the accuser, right?
It's the person who's distressed, right? The distressed party. Eric says he wants to sue, and I say I don't want to go that way. I want to do a mediation. It depends on the terms of the contract.
Right,
If it
so,
says
yeah.
may, then the person can sue, right?
Right.
But if it says shall, there's a difference.
Well, and it actually gives a little subsection in there that says, unless this is super bad. So even if you do select shall, if someone's doing something grossly out of line, you could go straight to litigation.
Yeah, but that has to be
Talk to your
ruled on by
broker.
a judge.
Yeah.
A judge is going to have to say, okay, well, your contract says shall go to mediation, and you're claiming that this rises above that level. You have to prove that it rises above this level.
Yeah, and there's good arguments for both sides. So I've heard great arguments for the shall and great arguments for the may happen side of it. So that's your guys' decision, though, but it is something that you should consider on doing something on the type of person you are, the type of home you're buying. Are you buying something that you might already know that it's, heavily distressed, or you've already done your due diligence a little bit and you might think there could be some issues, or you might want to be a little bit more careful on what you might want to do because it might be a riskier property.
And this is really, that's my favorite point. What do you want to do?
Yeah.
What are you willing to do? Do you have a lawyer in your back pocket already? Have you been through litigation? Are you familiar with it? Are you planning on doing something shady, or they're doing something shady that you're going to jump right into this?
Yeah, you want to be aware of it. And everybody, like I said earlier, everybody goes into that contract happy. We're going to agree on this. We're having a meeting of the minds. Don't think of it that way. Think of it when you really get ticked off and something goes and hits the wall. Are you one that is going to sue, or are you one that wants to avoid that kind of consequence, that kind of expense, and you want to go to mediation?
Well, and then just to also back up, this is in the purchase contract. So this is between the buyer and the seller, okay? Not between the client and the agent.
They always have to mediate first.
Those are separate agreements on separate stuff. This is in the purchase contract. I'm purchasing this home, so this is a disagreement between the buyers and the sellers.
Right.
Yeah.
Not the agents.
That's a good point. We should maybe talk about what happens when an agent has a conflict with one of their own clients. But just like Jason said, you have to go to mediation first. That's just always the case. All right.
What did we learn?
My key takeaway is that you should be wise about how you want to respond in the contract and enshrine that in the contract.
It's important to read and understand the implications of the contract, because even if you select may the options of the parties or shall, other language in that very same paragraph may change the outcome.
Well, and remember that this is your decision. It's not your agent's decision. You're the one that's going to be paying the fees one way or the other. It's still your purchase contract. So, make that decision.
We came to a peaceful resolution through mediation.
No, I sued him.
And I lost.
If you want to get in touch with us, shoot us a text at 801-228-7687. Make sure you mention the show. You can email us at theutahrealestateshow@gmail.com. You can watch this show on YouTube, and you can listen on Apple Podcasts, Spotify, or wherever you get your podcasts. If you learned something, or if you really love this show, give us a like on YouTube and drop a rating on Apple Podcasts or wherever you listen. The Utah Real Estate Show is a production of Hive Collective at Presidio Real Estate, with support from Security Home Mortgage. The NMLS number for Security Home Mortgage is 178787. The NMLS number for Jason Christiansen is 240472, Equal Housing Lender. Not only is this not legal or investment advice, but you should definitely talk to a pro before you make any real estate decision. Every situation is different and should be considered in context. Copyright Jason Christiansen, Eric Wist, and Tyler Kazare. All rights reserved. Talk to you next week.
Tyler, I'm suing you, you scarf-wearing, purse-pocket pant boy.
Hello and welcome to another episode of the Utah Real Estate Show. Don't do the poppy thing. Don't do the poppy thing.
Oh, we can do the other Jason thing.
Yeah, seriously. The bull snorting and the thing. I learned that Eric always wants to sue me, and I always want to go to mediation.
He's a sweet spirit.
Is that what you learned?
That was what I learned. My key
He's
takeaway.
a sweet spirit?
Oh, jeez. My key takeaway. Stop looking at the camera. There you go.